Thank you, Mary. It's nice to have an invitation to be here. This is a different group than I'm used to addressing. I speak almost exclusively to lawyers. You look friendlier. So some of my content, I'm adjusting my lawyer content, and if I'm clumsy and appear ill-prepared, that's what I am, clumsy and ill-prepared. So I'll apologize in advance. To give you a little positioning on what we do, we provide an insurance protection plan which insures estate trustees and executors from the liability that they take on during the course of their estate administration. So the position that I took on this as I got ready was looking at where we get brought into estate litigation, and I tried to start at the end and then work my way forward with some thoughts for you on some practices that you might want to consider, and they're not legal practices, they're more practical things that might avoid having you as an estate trustee or your executor or estate trustee that you've named in your own will involved in a lot of problems, and the problems are almost always involving family members. So this may result in limiting the family strife after somebody's gone, and hopefully there's a couple of kernels of information in here that you find valuable. And I have to remember to press my buttons here. So, the agenda today, and I just want to go back and give you a quick shot of my slide, but I think we took the one slide out, and we've got a picture of an estate sale that I took on the side of the road, and it's a sign that somebody has cobbled together with a magic marker and a piece of cardboard and some nice, it looks like a bread bag that was cut open and taped over it to protect it from the elements. That's essentially the marketplace and the level of sophistication that we're often dealing with. So when I look at these things, I'm trying to take it from the lowest common denominator and then pushing it ahead. So I think I'll talk on something that probably has relevance to very modest estates and large estates as well. So today I'll talk a little bit about a few areas: the executor liability situation and what their responsibilities are. Talk a little bit about will preparation gaps, some of the gaps that come from the financial planning exercise that financial planners are doing for their clients. Talk a little on power of attorney and how that can be a catalyst for trouble in the estate administration. And then I'll talk to you about some specific events that we encounter or specific claim situations that we run into as a result of what I think are often bad plans or resulting from gaps in the planning process. First thing I'll talk about is who the executor is, or the estate trustee. And the estate trustee is known as the personal representative of a person that died. Now, that's important because as the personal representative, they take on essentially the rights and the obligations of the deceased party. And that's important. So they're the person that can sue on behalf of the estate and that can be sued on behalf of the estate. That little bit in there that you can also be sued is you are the person that is sued if the estate has an action against them. Because an estate is a dead person, you can't sue a dead person. So you need a living body to take on that responsibility. That's something that most people don't understand until usually they don't understand it when they're naming an executor, but most executors don't understand that particular part when they take on the role. That's important from the standpoint that quitting is not an option in most cases once you start to take on the role, and that usually you usually become involved in that at the time of the funeral because the executor often looks after the funeral arrangements. So once you're into it, and it is difficult to get out or to renounce after you've started. Now, executors are personally liable to the beneficiaries. And that includes charities that might be included as beneficiaries. They're responsible to creditors. So if there are debts that the estate has, they also have a liability there. And they're also responsible to the third parties to the estate. So there could be contracts underway with that the deceased had. It could be car leases, could be cell phone contracts, other things that carry on for a period of time. And that liability follows the executor into those dealings with those third parties as well. Probably the most material part of all of this is the fact that it ain't over till it's over, and then it's not over. After you give the money away, after the distribution, the estate doesn't close. What happens is there are limitation periods during which people can bring actions, and the executor, even though they may not have access to money in the estate, they continue to be responsible for their activities. And if there's a judgment, they may have to put money back in to satisfy the judgment. Doesn't sound like a lot. You think it never happens, and it happens regularly, and it's a growing area of litigation. Some lawyers call estate litigation the new family law opportunity for lawyers. So you know how much money lawyers have made on family law in the course of the last 30 years. Look ahead 30 years as demographic is changing with aging population. Fact is, lawyers don't mention a lot of this, neither when you're preparing your will nor when you start to take on an estate administration. So this is a secret situation that exists. Lawyers run businesses fixing estate problems. They are, it is big business, and the costs that they have, the costs that they incur can run $500 to $600 an hour to solve estate problems. So it's a good reason to be looking ahead. You need to do good financial and tax planning, but there are other things within the planning process that are more important perhaps than putting numbers in boxes, and it's dealing with the soft issues that can become hard issues at the time that somebody passes away. And those hard problems that you leave behind for your family can be difficult and expensive to solve. So the areas problem areas or opportunity areas, depending on how you look at it, are inheritance planning, preparing your will, and financial planning areas. So, as I say, a lot of people only consider the money aspect when they're doing their financial planning. You need to plan around social issues that may not be jumping out at you. And the social issues are the soft issues that are taking place with your family. So when you're looking at division of money, you also need to look at not only who is going to be getting the money, what is the money going to do to the people that are getting it? Because sometimes that gets lost. There are people that should probably be treated differently, and the normal inclination of parents is to try to be fair with everybody. And fair is often thought of as equal. So we see a lot of wills where there is a more or less equal division of money. Equal doesn't necessarily imply fair, and it can be problems for various parties. Those problems should really be discussed in advance with the family, because often what happens is the will is the first time that somebody sees what they think is the expression of their parents' love or lack of it, because they open the will and they find out they've been treated differently or the same, and it's a shock to them. So it's a good time for parents when they're doing their will planning to actually have some tangible discussion with the family so that people know what to expect, because I would find from our end of things, they often have no idea what to expect, and when they do get the news, it can be quite shocking, particularly when it hasn't been explained very well by a parent, even with a letter that's attached to the will. Now, throughout this, I'll make some references to certain guides that we have, and we have a website, and I'm not making a commercial here, but if you go on our website, there are certain planning materials, will planning guides, inheritance planning guides. Anything referred to in this PowerPoint presentation is available at no cost on that website, and there's some great materials. So the inheritance planning guide is something that is different than a financial planner might go through, And it deals with soft issues, and it gives you a little bit of food for thought on what you might want to be considering when you're doing your planning process outside of putting numbers in boxes. Now, we see some opportunity for you as well in will planning. And I could say a lot about wills because the wills that we typically see that are the subject of litigation tend to be very old wills or very new wills. And it can be a frustration. We see a lot of 25 or 30-year-old wills. They haven't been updated, and they are completely inappropriate for the circumstances. So somebody was convinced at age 50 to prepare a will, which they did, and they've never touched it since. And I think most people would be hard-pressed to think that nothing material has changed in their life financially or otherwise in the course of 25 or 30 years that would cause probably a reason for opening the will and doing it again. I can tell you that lawyers, are there any lawyers in the room here that do will and estate planning? I'm not concerned here. My daughter's a lawyer, so I'm not going to make any disparaging comments about lawyers that she wouldn't support anyway. Lawyers are reticent to contact you to refresh your will. And the reason for that in some cases is because depending on who it is and how their circumstances have changed, it can open a new layer of liability for the lawyer when they ask you to prepare the will again, because essentially it isn't a refreshing of the will, it's a new will when you start to go through the will process. So lawyers often don't make a lot of money because they do flat feeing in many cases on will preparation. So it's a bit of a loss leader, and in some cases the lawyer's expecting they'll probably have an opportunity to make a bit of money at the end during the administration, because they often the person that prepared the will also does the administration. So when you're working on a limited amount of money coming in for the function, which is will preparation, you may not be looking for a lot more of it. So the fact is, lawyers will often leave that task to you to tell them when to do the refreshing. And often that doesn't happen because preparing a will is not high on the list of anybody's list of things that they really want to do. Dealing with our mortality is not something that's particularly fun or attractive to anyone. But having an old will creates all kinds of problems. Now, I'll give you another gap on wills. Oh, sorry. Having a new will is also a problem. So what we run into is when wills are refreshed, there's probably a better legal expression, but we call them deathbed wills, because we run into wills being refreshed often within 3 months and even closer to the date of death. So what happens is somebody is ill, they have the caregiver take them to the lawyer to get the will executed because they want to express that they have what they feel is a debt to a caregiver, and they want to reorganize their affairs to recognize that. Unfortunately, we see a ton of wills where there is an apparent capacity problem, and you've heard enough about that probably already today. The capacity issues should be dealt with properly. They often aren't. And what you'll have is a couple of wills, one real old one and one real new one, and they are completely different. But they follow a certain theme. When there's a new will executed, there's often a redistribution of assets to one particular party. And it tends to be, if not a caregiver, somebody that's done something nice for a person towards the end of their life, and they're trying to make a change. If you haven't been well, that can be a problem, and it's going to result in some litigation and that you can expect when the person passes away if there's a big change in the way that the assets are being distributed. An interesting thing is that we ask financial planners if they've seen their clients' wills. And my partner deals with the financial planning community a lot. And he's asked the question to rooms full of people like this 100 times, and the answer is almost always no financial planner typically asks their clients to see what the will looks like. Pardon me. Well, if you don't know if the will is reflecting properly what the financial plan is, you've got this disjointed function where you're making arrangements for your money, but you don't know whether that got embodied within the will. And that's partly a function of these old wills as well. However, in the will preparation side of things too, you need to provide proper information to your lawyer so that your lawyer understands what's going on with your finances. Because when they prepare a will for you, you'd like to see that the will is reflecting what the financial planning is. So this disjointed function goes on all the time. The financial planner doesn't know what the lawyer is doing sometimes, and the lawyer doesn't know what the financial planner's been doing. So now you get a will opened up, and if you add life insurance proceeds into that, you've got this peculiar. Thank you very much. You've got this peculiar set of circumstances where nothing seems to agree, and that can be a problem for the family. Pardon me. As much as I said, I'm not going to make this a commercial for insurance. There is insurance available for estate administration to cover the legal liabilities of the executor and the estate administrators, estate trustees. Doesn't cost very much. Every estate should look at it. A lot of lawyers write a provision in the will about that, and they say that the estate trustee can purchase insurance if they want, so the testator will make arrangements for that. So a number of lawyers that have never heard of it, because not all lawyers read a lot. They tend to be slow to change and slow to get caught up on news sometimes. So we still find that there's a large number of lawyers that make no provision in the will. It doesn't cost anything for the estate trustee, but some lawyers miss that. We think that's material. So being that the will is really the only instruction that the executor has on where to go, and they need to follow it, you want to be sure that your will is up to date. You want to be sure that it's properly executed and that you've given it a lot of thought. Because if it isn't any of those things, what happens is your son or daughter or any of you that have been named as an executor will open the will and they don't understand what the will means, or it's sadly out of date, and despite their best efforts to satisfy what the testator had, they're not going to be able to do it because it's impossible to do because of outdating or being improperly prepared. So what ends up happening at that time is that everybody's unhappy because the estate trustee is not able to do what the testator wanted. That makes brothers and sisters unhappy. It makes charities unhappy. And these are things that can end up with starting a state litigation for the estate. And that's an expense to all of the beneficiaries and to the executor and or executors that are involved as well. So we suggest that, and this is practical information, if you have an information package prepared to accompany your will that'll deal with some of the stuff that isn't in the will, but it gives the executor a place to start. We have some documents that you can look at, but things that we see that are often missed are, we're living in the electronic digital age now. Everybody does their banking electronically. They have passwords. They have social media accounts. They have all of the stuff that you have to enter, either 4 digits or a special word or your mother's place of birth or whatever the case may be. A lot of people don't do anything to keep that together. And they try to remember because they use a variation on different things. So a guy uses a word like Mustang, and sometimes it's Mustang 1, and sometimes it's Ford Mustang, and sometimes it's uppercase and lowercase. Your estate trustee steps into your affairs and tries to deal with managing your affairs, and they can't access your accounts. It doesn't sound like a big deal, except if it's a big deal if they're trying to manage your finances. And imagine if you were day trading stocks, as a lot of people do, because it's not difficult. They can't get into your stock brokerage account. It's not that you'll never get into it, but they won't get in for a while. And how long does it take for the markets to turn? These are important things. So we think that fill out the information package, do some pre-planning while you're able to do it, before you're incapacitated. Help your executor, which is usually a family member, look after things. If you have a complicated estate, consider getting a professional trustee to do the estate. So trust companies do have a role. Sometimes it isn't fair to ask a family member to be doing that. So you can think about using a trust company as a professional trustee, or you can ask them to be, the executor can use them under an agency agreement where they will do a lot of the work. They'll take a lot of the role that a person that feels that they're not able to do it will appreciate. They do it for a fee, and it moves a lot of the effort into the hands of somebody that's well qualified to do it. And there should always be a will direction put in to allow the estate trustees to purchase insurance protection to cover themselves while they're doing the estate administration. So those are some high-level thoughts there. So financial planners, good with the numbers, soft issues. They don't ask a lot about certain things because there's a failure in financial planning that we see, which is the way that financial planners get paid. So financial planning historically has been something that people do. Has anybody in here, you ever gone through an estate plan with a financial planner where they ask you the questions? It's the numbers and boxes thing. And at the end of the day, what it typically does is it generates a sale. So when you answer all of the questions, at the end you need $1 million of life insurance. Or if it's better, you need $10 million of life insurance. That happens to be the process that is often followed. All of the soft issues that are related to your financial plan are things like family history, relationships. These are dynamic things that change all of the time, and they need to go into your financial plan as well. Your financial planner has to understand these things. A big thing that gets overlooked a lot is family law. Now, half the population will have a divorce. A lot of those people will remarry. And family law circumstances have a profound impact on how an estate will go. And you need to think around that. A lot of people will take a check, for instance, and they will pay off debt. And this being the most debt-laden population that we've ever seen. People get an inheritance, they take a check for $50,000 and they pay off their creditor bills with it. You can kind of think that every couple is somewhere along the continuum of marriage to divorce. So if you're sort of halfway, what a terrible thing to say. If you're sort of halfway there, you're probably okay. But if you're towards the side of, you know what, my marriage is terrible and I may be getting a divorce, some good advice is don't use that money to pay off debt because inheritances are protected. So if somebody pays off debt for a couple, the money's gone. Now you get a divorce and you just gave half your money away to your son or to your husband or wife, and you would have liked not to have done that. These are things that really need to be well thought out, and the financial planners, if they explore this sort of thing with you, they'll come up with usually interesting information that will help them in preparing a financial plan for you that can do your survivors a great deal of service. You should always provide a copy of your will to the planner. You should have them do the comparison of your will to their financial plan to see whether that will is properly reflecting the plan. And if it isn't, then you need to think about what you need to do to correct it so that you don't have that conflict in terms between financial planning and will planning, which is a big problem. Another thing that we see on financial plans, your financial planner, and a financial planner can sell you mutual funds, they can sell you life insurance, they can be a stockbroker. I mean, they've got a wide range of things that they do. The one thing that they don't do very well is they tend to ignore younger beneficiaries and people that don't have a lot of money, because these people tend to eat what they kill. So if there isn't a sale associated with doing financial planning, they tend not to focus a lot on it. There are exceptions, some do fee-based planning. But you may want to introduce your financial planner to your children, because they typically don't have a financial planner because they don't have much money. They will come into money at some point if you leave them money. And if they have a chance to talk to a financial planner, they may not have anything to buy, but they may be able to glean some knowledge from the financial planner that will help them when they come into some cash. Because the next generation is a lot different than the generation sitting here. I look at my own kids. They don't see mortality, they see student debt, they don't see ways to invest, and they've never had a lot of advice on it, and it's a good opportunity for you to steer them in that direction. Power of attorney. I am no expert on power of attorney, but I do see the fallout from it from day to day. So thinking about where I start, and I'm trying to slow my presentation down here, Mary, too, so I'm sensitive to filling the afternoon. Usually people tell me they can listen faster, so. Power of attorney, typically prepared with your will. Is that your experience in here? Lawyer does the will, they issue a power of attorney at the same time. How much time did they spend talking to you about the power of attorney? 2 words, be careful. Well, there's a reason for that. There's 2 reasons, really, as it's been explained to me. First of all, we talk again about wills being sort of a commodity product. Lawyers don't make a ton of money at wills, tends to be flat feet a lot. They tend to include the POA along with the will preparation. If you're not making a bunch of money on the will preparation, because that's the way it is, are you expecting that you're going to get a whole bunch of extra effort put into explaining the power of attorney for property? And I'll stay away from personal care, not my area. It's probably unreasonable for for us to expect the lawyer to spend a bunch of time on power of attorney. Yet it's a huge risk area. It has a ton of abuse, and it's got fallout not only for the grantor of the attorney, but for the beneficiaries to the estate. There's one reason. The other reason is the lawyer really doesn't have a need to explain to the various parties, whether you have a couple of people acting as your attorney or one. The lawyer rarely spends any time with your son or daughter or niece or nephew, whoever you've appointed as your power of attorney for property, because they don't have to, for one. And number 2, if they're not doing that because they really don't have an issue to discuss, they don't have a legal liability. So to bring more people into the power of attorney situation isn't a better thing for a lawyer, it's probably a worse thing. So they're not making a lot of money at it, if any, and they don't want to find a way to spend more time doing more things around an enterprise that's making them no money. Probably not unreasonable. I think the failing is if a lawyer wanted to take another look at that, I would split that function into 2 things. I would do will preparation, and I would do the power of attorney as a separate meeting, and I would have a different charge that I would be attaching. There may be a specific charge to it, but I would have a different meeting around power of attorney because it's that important an issue. So often what we find happening is that the grantor knows little or nothing about the granting of, when they grant the power of attorney, about what's going to happen. And I only caught a couple of words as I walked in from the last speaker mentioning legal liability when you're acting as the attorney as well. So the person granting doesn't know a lot about it, and the person that is acting as the attorney also doesn't know a lot about what their situation is. That's a terrible position to put anybody in. Total lack of knowledge, control over someone's finances. It's got all kinds of prospects for a problem. Now, aside from lawyers telling you to be careful with your power of attorney, I find that many people do little or nothing to qualify the person that will act for them, other than they trust them. So I think trusting is probably an important issue, but the fact is, you really want to think about qualification as well. And I think at some level, everybody probably thinks something about qualification, but we look at it from an underwriting standpoint. So as insurance people, we look at risk and we try to put together a risk picture and decide where is risk big and where is it small, and what can you manage and what can you not manage. You need to think about some of the things that are to us obvious that don't end up being obvious with appointment of people. So we look through a lot of case law on litigation that comes out of power of attorney, and there's a theme that runs through it. The people that act as your attorney, that steal money, it always starts the same way, and it starts with doing a good job right off the bat, and then it goes to paying bills for themselves because they manage to decide that they're benefiting the grantor. And those amounts get larger and larger. And then it goes to the point where they justify their activity by saying, I'm going to get the money anyway. And now what you have is that people are picking through the estate because they think it's their money, and it's all a mess. And that mess follows into an executorship because the attorney is often the executor of the estate. That's just the way these things go. You should be thinking about the qualification of these people. One thing that I don't know if people spend much time thinking about is ability to keep records, because this is an accounting function. And if you're not good at keeping records because you're quite trustworthy, but you can't balance a checkbook and you can't keep records of what things are for, it will be a problem, because there will be a transparency that develops during the executorship, if you are indeed the executor of the estate, where people will be looking backwards at your activities. That's kind of a basic situation. I can tell you that there is a theme that runs through. Youth is one of the issues. So people that are granted power of attorney that are young, don't have a lot of their own assets, and have to service debt are probably should probably be looked at closer than someone that is older, that has more financial wherewithal and experience, and doesn't have a need, an actual profound need for more money. And yet we see lots of activity where you have a kid that's really not qualified to be managing someone else's money, and they fall into that role because they were trusted and loved. Trusted and loved is important. Qualified and able to do the task. I think you have to be very critical when you're going to grant your power of attorney to someone, because they can be giving your money away. They can be stealing your estate from the beneficiaries, as we call it, one tube of toothpaste at a time. It's the way it starts, but the finish of it is often worse than that. We think that periodic passing of accounts by your attorney makes sense, and as much as it's not practical to have multiple people involved in the function, because it's got limitations and difficulties, makes sense to perhaps have more than one person, and to have somebody reviewing those accounts that are well documented, so that you have rules around managing the cash, and that will solve part of the problem moving forward. Because if you don't have that, it will be a problem down the road. It can be anyway. So there's a little background. And I'll take you ahead. And I said that we look at it from a claim litigation problem. So the causes of estate problems that will stem from failing to pay attention to some of the issues that I've talked about here, they deal with family matters, they deal with finances, following directions, and communications. Those are the areas where estate problems generally develop. So from the standpoint of family matters, excluded parties and dealing with parties differently, often a problem. Less a problem when it's explained. So if you have somebody that's got a lot of money, one of your beneficiaries, they've got a lot and they don't need a lot, if you explain why you leave more money to someone else, it generally solves the problem. If you don't, it's mom always loved her more than she loved me. And that's a problem. And people will litigate on that over no money. We see that all the time. Extended and blended families. This is a major problem. Family law issues will be compounding problems within a state administration for the next 30 years. It's a greenfield opportunity for lawyers, and it needs to be really well thought out, and it often isn't. It's difficult to talk about. Second, third marriages, multiple kids, some who have never met each other. Imagine dealing with all of that as an executor, trying to communicate with these people. Dependency issues. Anybody here ever pay a visa bill for one of their kids? I have 5. Lots of student debt. We lend money to the kids. I don't document it very well. Those debts really are liabilities to the estate. These are things that don't get documented, don't get talked about. People don't tell the other kids because the other kids would say, don't give them money. You got dependency issues, so these people can claim, will try to make a claim for dependency in the estate. So this kind of problem. Cottages. You've heard enough about cottages. And then the last thing that I threw out at this point is pressure to distribute the money early. Everybody needs the cash. And now we're in the digital age. So you've got text messaging, you've got BBM, you've got email, fax. Everybody expects one thing from all of this, an immediate answer. Anytime, anybody that's got kids, you ever get a text message from a kid? How long do they want to wait for an answer? That's right. 1 second would be probably too long. That's the environment that estate trustees are working in. So these are problems. Finance problems. Charities are not friendly when they're beneficiaries. And people don't understand that until they're an executor trying to deal with an aggressive charity that wants to be sure that they're getting every penny that they're entitled to. They historically were treated sometimes not well, where the family would prefer themselves over the charity that was left the money. That doesn't go on anymore. And some of the charities that are the most vigilant would be quite surprising to you if I made a list of the names. Poor management of financial assets, another problem. The loans to the family members that are undocumented requiring repayment. Power of attorney acrimony that carries over to the estate administration. Every penny that got spent will come to bear for that executor if they were power of attorney for property and did not do a good job at it. It often ends up in litigation. And here's one that I could talk about forever. Gifting of joint property and investments so you don't pay tax. Anybody ever heard of that? Put your bank account in your son or daughter's name along with you. It's easy. They can, it kind of transitions into the attorneyship. They can manage a bit of money for me. And then we know what happens. Somebody says, well, we don't want to pay the estate tax. We're going to save some money. The estate tax is like, it's not that it isn't a material amount of money, but sort of rule of thumb about $15,000 per million in Ontario. The amount of money that we see wasted over trying to avoid paying a state administration tax, either by structuring life insurance to try to get around paying any estate tax. And the average estate in Canada, 92% or less than $1 million. we see people who spend $50,000 on various planning methods to avoid estate administration tax. That'll be a third of the amount that they're spending to avoid. That's quite common. The worst part is, when you die, if it hasn't been properly documented, the asset rolls into the hands of that survivor, and that survivor can end up with either all of the property that they were, if they've got it and they decide that they're not going to give it to the estate the way you intended, or maybe even worse, they end up with a tax liability because just because they're a survivor doesn't mean they're a spouse. And these are things that are, there's some mystery involved in these things. But ultimately, these joint accounts that are set up to avoid tax, major problem. We see it all the time. So you really need to think hard about it. You need good advice, good legal advice and good accounting advice. Following directions: poorly drafted and outdated wills. Those are the things that cause problems. Conflicts of interest when the executor is also a beneficiary. If you're going to make a mistake, human nature will sometimes say, I think I'll make that mistake in my favor. And that can be a problem with the other beneficiaries. So you need to be very clear in your will provisions because it can be a problem. And communicating. Communications are a problem, especially with these extended families where you may run into cases where the family members have never met. You as the executor may not have met a son, a daughter from a step-parent. People are in different countries. It's a small world now, but geographically it's still big. You get people all over the planet. Executors can miss beneficiaries, and then they're personally liable for the mistake that they made. Okay? Imagine finding out about that. I'll tell you what we run into. Dad and mom were separated, and unbeknownst to anybody, Dad had a relationship somewhere else, and there are 1 or 2 children from that relationship. We don't run into that occasionally. We run into that regularly. Okay? Comes as quite a surprise to everybody. So communications are interesting. We could probably make a list of all of the things that we encounter from a claim standpoint, some that would make your hair stand on end. Some are just so terrible, we don't even like talking about it. We have, in some cases, people that prepare a will and they try to right a wrong that they did during their life, and they want it hidden from the public. So they try to put the correction of that problem into their will. Okay? Imagine being an executor and opening the will and finding that Uncle Bob had a problem with one of your cousins and tried to cover that up by dealing with it in the estate by leaving money behind. Okay? These are the kind of problems that we encounter, and there's all kinds of them. The things that I didn't know about 5 years ago, it's really quite astounding. And these are huge problems for your estate trustee and executor, huge problems for your family, and they come from poor planning or gaps in planning and having a kind of a fragmented approach to getting your affairs in order. I hate using that expression because it sounds so final, but it's really what it is. So some advice on avoiding estate problems. Identify the issues that can give rise to problems. It's not planning for numbers. It's not putting numbers in boxes. Plan and review your power of attorney and your will. Make sure that they reflect what your intentions are. Keep them current. If things change them. It's not expensive. You're not going to incur tens of thousands of dollars to change your will as a rule, the average person. And think about putting an insurance provision in your will, if your lawyer hasn't already done it, that says that your executor can buy insurance to protect their own personal liability if one of these problems that comes out of communications, finances, bad planning does come around and haunts them. So, and people say, how much does insurance cost on an estate? Typically costs, for 92% of the estates in the country, that take less than 3 years to administer, it'd be sort of $1,700. The estate pays it. So it's inexpensive. It's about the cost of the photocopy bill for the estate litigation if your file goes to court. So our website has all of these planning tools. You're welcome to go on there. You'll find some really good stuff. It's been prepared by the experts that we know in the field, and there's some other interesting material on there as well, so you're welcome to use that. Thank you for your patience, and nobody threw buns at me, which is a nice change. I'm happy to answer any questions if you do have any. I'll just start with this lady first. She got her hand up first.
Looking at me?
No, behind you.
I thought you were looking past me.
You're next, sorry.
Just before you answer questions, could you repeat them so that the audience at home can hear what the question was?
Yep.
Thank you.
You were talking about unknown children that come out of the woodwork. When a father has legally given up the rights to his child, to her and her parents, would that, my grandchild, then have the right to come back on my estate?
What a great question. So the question is, if the parent has given up rights to the child and the child materializes at the time of death, do they have some right? The sad thing is, or the good thing, depending on who you are, there's no, you need to get a lawyer and go to court to determine what you can and can't do. So there's litigation that comes out of any kind of a question. A person can sue for what they want to sue for, and you have to pay to defend it. And the scary part of that is if you've distributed the estate and there's no money left and that action comes in and you're the estate trustee, you're writing the check. And it may only be to defend, but nobody wants to pay $500 an hour and $5,000 a day in court time to be determining that their right was barred to sue the estate. So
So the litigation insurance, how long would that be valid on the estate after the closure of the estate? Like, say somebody came up, grandchild came up 3 years later.
well, great question. The policies run, our policy, and there's more people that probably sell it, our policies run for 3 years and they can be renewed. Statutes of limitation, which are the rules around when you can and can't sue any longer, run from sort of a short of 2 years to a long of 14 years, depending on the last time you did something. And sometimes you have to get a court determination of what your action was and when the statute of limitation comes in. So we renew these policies for people if they're concerned about that.
Just a clarification on the 3 years from the end of the closure of the estate, or 3 years from the time you start?
Start,
The mill starts.
yes. I'm sorry, ma'am?
Can you run by once again the disadvantage of the word's gone, so what happens when you get this old of jointly owning investment portfolios and bank accounts?
Yes, so one more time on jointly held accounts. Jointly held accounts for the purposes typically of trying to avoid a state administration tax.
Right?
The risk is that if your will isn't dealt with and prepared properly, there is a risk in some cases that the survivor on that jointly held account, when not a spouse, will end up with that asset. And you may be thinking that that asset, if it was a car or an investment account, you may be thinking that that's going into your estate. And if not properly prepared, it may be going into the hands of one person rather than everybody that you intended. So it's not that it may be an effective strategy for some, but we think that it makes sense to have thorough legal and accounting advice on that because it has a fairly profound risk to a lot of people. Sir?
My question is, how much time does it take to be an executor of the estate? I mean, if I want to find somebody who's very busy, maybe he just won't have the time to do it.
It's a good question. How much time does it take to be an estate trustee? That varies according to the size, complexity, and family dynamics probably of the estate. It can be quite small if you have a simple estate. It can be quite detailed if you have a difficult estate. Difficulties can come out in a whole bunch of different areas. So to give you a simple answer on that, All I can tell you is it's more difficult than you expect when you start.
Another question. It's probably a bad idea. I had my son planned to look after our estate, but it comes out now that there's everything wrong with that. First, he'll be executor, he'll be a main trustee, main beneficiary, and it's just about everything but he shouldn't be. So I have to start looking for somebody else I can trust.
Well, that's interesting. That's what my dad said, too. Sir, at the back?
Do you have instances, and I'm sure you do, where there's, say, 3 children and one of the children gets written right out of the estate? And then in that case there, the second part of the question is, does that individual have a successful claim against the estate?
So the question is, if someone is written out of the estate, do they have potentially a successful grounds for a claim against the estate? I am not a lawyer. I can suggest to you that in Ontario, they try to honor the wills of the testator as much as they can. However, if you were in BC, they changed the legislation in British Columbia in the last couple of years. And under their legislation, if you can convince a court that there has been some unreasonable unfairness in your treatment or your exclusion as a beneficiary because it just isn't right, then the court has the power to redistribute your estate to include that excluded party. Sorry.
One more question then there is.
Ma'am?
Why can the limitation period, you said, could be from 2 years to 15 years? Is that because of minor children that can come back after the estate when they reach the age of majority?
At a high level, it's because depending on your activities, depending on what you're doing, if it's distributing money, if it's paying taxes, if it's family law related, you can do so many things that may have a different area of law applying to it, because whatever law is out there that governs the activity that you're doing, whether it's selling real estate, liquidating assets, doing some family law thing, there are different statutes of limitation from all of those activities, and that's why you have to determine when you did the last thing and what act may govern and how long your responsibility runs.